We spent all day yesterday defining the challenges that confront rule of law communities around the world. Today, we pivot to solutions.
To create an anti-corruption court, maybe it's not an easy task, but we are here not for easy tasks.
Totally new courts have been set up, administrative courts with 150 new judges where people could sue the state agencies. 52% of them, they're winning the case against the state. So
data is critical because we use data for identification of the needs of the people.
Changing laws does take time, but in the end, it's the thing that actually makes sure that compliance is sustainable.
Good morning, everyone, and welcome back to the World Justice Forum. As you can see, we had a very exciting day yesterday of looking at solutions that work, and this short little recap video gives you just a glimpse of the dynamic set of activities and conversations that were taking place here at the forum, but also all across the city of The Hague at our offsite events, and we're so grateful to our partners and the municipality of The Hague for opening their doors to us throughout the city. It was a really rich day. So today's theme is taking action, and we will have a series of plenary discussions and working sessions around recommendations and commitments that we all can make as we leave this forum for building more just communities. Just to give you a couple of housekeeping notes, we will be meeting in this room 3 times for this morning's conversation in honor of Supreme Court Justice Ruth Bader Ginsburg. We then will break out into working sessions, and then we will convene here again at 1300 for a plenary discussion on the topic of recommendations and commitments. We'll do another set of working sessions on multi-stakeholder partnerships and collaboration. I think that is a really important theme that we're trying to address here and bringing together so many different diverse sectors on how we can work together. And then we will come back at 16:15, 4:15, for our closing plenary and the announcement of our World Justice Challenge award winners. A very exciting time for you to be in the room and to hear who will win the 5 prizes for the work here. I hope you've all enjoyed the showcases yesterday. I've gotten so much positive feedback of how much learning took place, and we're excited to have them in the expo here. Please take the time to get to know their projects as you walk through the expo area. So on the final housekeeping notes, we are asking you all to look at your app. There's a place there where you can fill out a survey. We really would like your feedback on how things are going, and take the time. It won't take much time. It's there in your app. You may have heard that today in The Hague there's a transit strike. So there will be no public trams or buses. There will, however, be trains to the airport in other parts of the country. So please factor that into your travel plans today. Importantly, we're also hearing about delays at the airport, at Schiphol Airport, particularly for outbound travelers. So we ask you to please consider in your travel plans as you leave an extra amount of time, maybe 2 or 3 hours extra in order to get to your flights. Finally, for those who need a COVID test before heading out in order to your outbound travel, we do have a testing operation in the front of the building, and they can give you the certificate you need for a negative rapid test. And with that, I would like to invite Judge Margaret McEwen to the stage to begin our conversation in honor of Supreme Court Justice Ruth Bader Ginsburg. Welcome.
Good morning. My name is Margaret McEwen. I'm a federal judge in the United States and also a member of the Board of Directors of the World Justice Project. And it's my pleasure to welcome you to the Ruth Bader Ginsburg Legacy Keynote. I am pleased to be introducing this plenary, and it is especially an honor for me because Justice Ginsburg was my good friend, my mentor, a fellow believer in international law, and also a fellow music lover. So let me begin by expressing our sincere thanks to the Ginsburg family, who enthusiastically embraced our suggestion that we have this event honoring their mother at this year's forum. I would also like to thank our sponsor, Uber, for their support for today's event. We convene this week under the theme of building more just communities, and realizing that that vision was certainly at the heart of Ruth Bader Ginsburg's career as a legal scholar, as an advocate, a teacher, a judge, and then a justice. She envisioned a more equal and just world, particularly for girls and women, and she worked tirelessly throughout her career to make the law a more reality for this equality. She left an indelible mark on US jurisprudence, and her influence did not end at the border. Rather, she was an active participant in the global movement for justice and rule of law. And we also are honored because she was involved in this forum from the very beginning, both as honorary chair and also as keynote speaker at many of our events during various forums. This Justice Ginsburg Forum keynotes were always a highlight at the forum and our convenings, and they inspired us to reach higher and farther in our quest for justice. One of her messages really resonates with so many of the remarkable challenge projects we've seen at this forum. Here's what she counseled us. Whatever you choose to do, leave tracks. And that means don't do it just for yourself. You will want to leave the world better for your having lived. We miss her especially as we come together at this forum again this year, and also that is the reason that the World Justice Project Board of Directors decided to create this Ruth Bader Ginsburg Legacy Keynote, and also to seek a speaker who could really inspire us as Justice Ginsburg did on numerous occasions. So it's my pleasure to introduce you to just such an inspirational voice, Sherrilyn Ifill. She is President, Director, Counsel Emeritus of the NAACP Legal Defense Fund. And that is the leading organization in the United States for advancing the cause of racial justice. For a decade, she has been doing so against the backdrop of mounting challenges. Sherrilyn has brought a visionary leadership to the Legal Defense Fund, fighting critical battles against voter suppression, inequality in education, and racial discrimination. Also, in the U.S. criminal justice system, racial discrimination has been a key foundation of the Defense Fund's work. The United States ranks 111 out of 139 countries in the WJP Rule of Law Index for criminal justice. The first 2 days of this forum, we devoted ourselves to defining challenges and identifying solutions. So today our theme, as you heard, is action. What are each of us and the organizations and institutions we represent going to do to build more just communities? Sherrilyn is certainly a woman of action as well as ideas, and we're lucky to have her with us to inspire us in our next steps together. Sherrilyn will be joined here today by Lisa John, Secretary General of Civicus, a leading voice for global civil society. We will begin the program with keynote remarks by Sherrilyn, and then we will take you to a conversation with Lisa and Sherrilyn and our audience. Should you wish to pose questions, just go to your app and use the session chat function and send your questions. And they will appear magically on an iPad here on the stage. So please join me now in welcoming our keynote for the Ruth Bader Ginsburg Keynote for Justice Lecture, Sherrilyn Ifill.
Good morning, and thank you very much. I want to first offer my thanks to the two gentlemen I call the two Williams, Bill Newcomb and William Hubbard, for inviting me to be part of this extraordinary gathering. Betsy Anderson for also inviting me and being such a wonderful support to get me here and to make sure that I could participate. And of course, Judge McCune for that lovely introduction, and all of you for being here. I could not be more honored than to be speaking at this particular session of this conference this year. It seems as though we've barely had an opportunity to recognize the extraordinary work and contributions of Justice Ginsburg. They are ever present in my mind. And so I look forward to this discussion today. I won't be before you long because I'm anxious to get to the conversation with Lisa and to hear from all of you. But I did want to say a few things about Justice Ginsburg and also about this moment that we find ourselves in the world as relates to the rule of law. And I hope you'll forgive me if I speak often about the history and situation in the United States, which is obviously where I'm from and where Justice Ginsburg practiced and served on the United States Supreme Court, and also is a place facing its own rule of law challenges. And so I'd like to use it as a platform to talk more broadly about the issues that we're all gathered here to engage with. When Justice Ginsburg passed away on September 18th, 2020, I confess I was devastated. It had already been one of the most challenging years of my professional life. The organization I led since 2013, the NAACP Legal Defense Fund, had been in a pitched battle to protect the rights of Black individuals, families, and communities during the final year of the Trump administration. Our work focused on ensuring the right of every eligible Black citizen the opportunity to vote, to protect educational access, to ensure economic justice for Black families and communities, and to address racism in the criminal justice system. This has been the work of the organization since 1940, when it was founded by the legendary civil rights lawyer Thurgood Marshall, who with his team at the LDF essentially created the field of what we call civil rights law in the US, but you might refer to as human rights law. In 2020 in the US, there were two uniquely difficult challenges to our work protecting the rights of minority communities: COVID and Donald Trump. So when we heard in the early evening of September 18th, just 2 months before the presidential elections, that Justice Ginsburg had passed away, it was especially devastating. I was interviewed multiple times that evening and in the ensuing days, and in each interview, I, of course, talked about her extraordinary contributions, but when I was asked what we would miss about her, I repeated what became a kind of refrain, that the court had lost its only remaining civil rights lawyer. Ginsburg, I explained, was one of only 2 civil rights lawyers who have ever sat on the United States Supreme Court. The first was Thurgood Marshall, who I referenced earlier, the founder of the organization I led, who became the first Black lawyer to sit on the Supreme Court. Marshall's work leading the LDF, litigating civil rights cases over decades, and successfully arguing before the United States Supreme Court, hit its peak with the Supreme Court's decision in Brown versus Board of Education in 1954, which, for those of you who don't know, began the end of legal apartheid in the United States. And I'll say it again because sometimes that seems unusual to people. Racial apartheid was legal in the United States until 1954. And Marshall had worked with his team at the LDF for 20 years, beginning in Baltimore in 1935, executing a legal strategy that culminated in the decision in Brown. Now, the case didn't end legal apartheid all at once, but it was a brick that, once removed from the wall of discrimination, began to crumble the legal framework that had held up legalized racial discrimination in our country. And once the wall holding up that legal infrastructure of racial discrimination began to crumble, it opened a crack in the wall of gender discrimination, which Justice Ginsburg was such a powerful figure in beginning to dismantle 20 years later, and still 40 years after that, helped dismantle the wall which held up discrimination against gay and lesbian members of the community. No lawyer was more responsible for removing legal barriers to the equality of women than Ruth Bader Ginsburg. As a young lawyer, she followed the template of Thurgood Marshall to pioneer the field of women's rights law in the US. She was often compared to Marshall, a comparison that she modestly eschewed. She would always remind commentators that Marshall, a Black man, had risked his life traveling through the South and litigating cases in some of the most dangerous and violent days of white supremacy. She, Ginsburg insisted, had never risked her life in the fight for women's rights. She had been, however, a victim of gender discrimination, of course, unable to obtain a job at a law firm despite her impressive performance in law school. But she ended up teaching law and created a project at the American Civil Liberties Union devoted to the fight for women's rights. But Ginsburg always admitted to using the strategy patented by Thurgood Marshall of painstakingly filing and litigating cases that would strike blows at the legal foundations of discrimination until it could no longer be sustained. And I will just say that one of the things I loved about Justice Ginsburg was that, in addition to crediting the strategy of Marshall, she also credited the intellectual and strategic contributions of Pauli Murray, a Black woman lawyer whose own confrontation with race, gender, and sexual orientation discrimination fueled her critical contributions to the more well-known work of Marshall and Ginsburg. But as former civil rights lawyers, Marshall and Ginsburg brought to the Supreme Court something particular, unique, important, and critical to our understanding of the rule of law, which is, of course, what has brought us all together for this conference. It's important to identify this, in my view, because we are in a moment when the rule of law is challenged around the world, but no more so, I'm sad to say, than in the United States. There is also deep skepticism among many in the communities of people I represent to the very concept of the rule of law. They often see it as an inherently suspect concept, one which, in their view, locks in the status quo of inequality and excludes the truth about the law as it manifests in the lives of those who live at the margins of our society and for whom far too often the law has been an instrument of oppression and dislocation. These are arguments that must be engaged. Now, when I talk about the rule of law, I refer, of course, to principles which I think we would all recognize, that the law applies equally to all, the powerful and the powerless, that it secures procedural as well as substantive justice, that crimes of corruption, of obstruction of justice, witness tampering, conspiracy, or racketeering must be prosecuted, both against the local gang lord and against those who work at the highest levels of government and business where appropriate. The rule of law means that we do not abuse legal power by shielding our friends from the legal consequences to which we would expose our enemies. The rule of law means that the law is not used as a cudgel to control the powerless or as a tool to further lift and enrich the powerful. The rule of law demands accountability for those who break the law, but assigns heightened responsibility to those with the obligation to uphold and enforce the law. The rule of law requires transparency and consistency in the decisions of our courts, especially our highest courts, which must set an example by operating with as much transparency as possible and must be willing to bind itself to ethical standards and to decision-making which is anchored in written explanations so that the public can understand why the court does what it does and not just absorb decisions from on high. And Justice Ginsburg was especially zealous about the importance of an independent judiciary to the rule of law, something I think powerful and important, especially today, hearing the news from Tunisia. All of these applications of the rule of law, I am sad to say, are under varying levels of threat in the US. And so it will require our profession, the profession I'm a part of, the legal profession, to get serious about our obligations to democracy. The unraveling of the rule of law always results in the unraveling of democracy. Justice Ginsburg epitomized in so many ways the best of the rule of law. She was a proceduralist and had taught the rules of civil procedure for years. I was speaking with a lawyer from Sweden last evening at the reception about meeting Justice Ginsburg there. In fact, in the early 1960s, she lived for a while in Sweden. She learned Swedish in New York and came to the country to work on a book about civil procedure in the Swedish legal system. I share her passion for procedure because I long believed what a great American legal scholar once said, that procedure is the blindfold of justice. Justice Ginsburg understood the importance of not only the words of a constitutional provision or statute, but the meaning and the spirit of it. Her opinions were meticulous and eloquent. On a panel on which she and I sat, I want to say in 2008, on women in the legal profession, she remarked on what she thought was the one difference between the opinions between she and the other woman then on the Supreme Court, Justice O'Connor, and their male colleagues. And Justice Ginsburg was not one to make jokes, but she did say that she thought that the principal difference was that the women didn't waste time taking pot shots at the other justices in their opinions. They got right to the point. But Justice Ginsburg, like Justice Marshall, brought another dimension to thinking about the rule of law, and this is what we will miss most. Because of her experience which was as a practicing lawyer, Ginsburg was acutely aware of how gender discrimination actually manifested itself in the lives of women. That is, not just what the law says, but how it actually works in a society dominated by ideas of male superiority. This acute awareness and her insistence on finding opportunities to educate her colleagues on the High Court and the public about this legal reality for women compelled a more complex understanding of the rule of law. In one of the most famous examples of this, Justice Ginsburg offered a dissent from a majority opinion in a case called Ledbetter versus Goodyear Tire. The case involved a woman, Lily Ledbetter, who had worked at the Goodyear tire plant for 20 years. She was unaware that her male counterparts in the same job as her were being paid substantially more, until by chance she happened to see the pay stub of a colleague. The question in the case focused on whether the back pay she was owed should include the period only after which she learned of the pay disparity, or should it include the period before? Adhering to what they saw as the strict language of the civil rights statute that covered these kinds of cases, a majority of the court held that Ms. Ledbetter could not recover damages for the period of time that the pay disparity was unknown to her. Justice Ginsburg's dissent, which she summarized in an oral reading from the bench, which is an unusual act for a Supreme Court justice, explained to the court and to the country just how pay disparity often operates in the workplace, and why a woman might not know, indeed be in no position to know, that her male counterparts were being paid dramatically more than her. That her opinion was a dissent did not diminish its significance. In fact, Justice Ginsburg explained later that her dissent was directed actually at Congress. Indeed, she ended the dissent by saying, "Congress, it's now in your court." Months later, Congress passed the Lilly Ledbetter Equal Pay Act, and it became the first piece of legislation signed by the then new president, Barack Obama. This sensibility of how the law actually works in the lives of women showed itself in countless opinions from Justice Ginsburg, not just those affecting women's rights, but time and again her opinions made clear that she was acutely conscious that the lived experience of the law should have a place at the table of deliberation. When Justice Marshall retired from the bench, many of his colleagues, including those with which he was often most diametrically opposed, wrote encomiums to Marshall's contributions in the conference room where the court privately deliberates. One justice wrote that Marshall told them things they did not know by virtue of their experience, and things that they perhaps would rather forget. Marshall's stories about the way confessions were coerced from black men by Southern sheriffs, about the exclusion of black people from sitting on juries, about the way the death penalty is meted out along racial lines. These stories were critical ingredients to a just application of the principles of the rule of law. In a society in which vast inequality is deeply embedded in its traditions and legal systems, the rule of law must be guided and framed by an understanding of how the law actually works in the lives of those most marginalized, those whose voices, until only a few decades ago, certainly in the US, had no weight or input in how our laws were written or devised. Justice Ginsburg, like Justice Marshall, brought this sensibility to her understanding and application of the law and set an example for other judges to do so. Now, it is not that justices who have not had this experience representing those most marginalized cannot themselves understand these truths. They can, and often they do. But it is that personal experience up close with this reality and the authenticity that comes from litigating on behalf of those contending with inequalities that is now missing from the Supreme Court in the US, where a majority of justices formerly served as prosecutors or political appointees in government. Something will be missing. We hope that our soon-to-be new Justice, Ketanji Brown Jackson, who served for a brief period as a public defender and is herself a Black woman, will bring her experience representing criminal defendants to the conference room to enrich the court's deliberations. And we hope that she's not arriving too late. There are troubling signs that our Supreme Court increasingly appears disinclined to thoughtfully consider these truths, to add to their understanding of the law those whose experiences could teach the justices what they do not know and perhaps what they would rather forget. And so those of us who are civil rights lawyers and activists must keep pressing. The rule of law is strengthened by an ecosystem that does not include just lawyers and legislators and litigants and judges. The ecosystem includes the work of community activists and organizers. We know it's also shaped by economic cycles and global trends, by war and peace, and also by corruption and bribes, special interests, and ego. But despite what are often the negative influences on that ecosystem, what keeps me encouraged is knowing how many of us, represented by this extraordinary gathering, are seeking to shape this ecosystem to uphold the integrity of the rule of law and to strengthen the law's ability to dispense not just law, but justice. Thank you very much.
I have to start by giving you a hug for
Let's
that
please.
amazing and very inspiring address. So firstly, I just want to reinforce the significance of this moment. This is the very first legacy conversation, inspired by the legacy, of course, that of Justice Ginsburg, but it's also the very first opportunity to then celebrate your own work for against racial discrimination and the work against systemic injustices. One of the things I do for a living is actually look at the trends in civic space and the trends in protest movements. The idea of justice has really been the driving force of all of the citizens' movements we've seen across the last decade. And what we've noticed is that people's action, people power is at its strongest when the idea of justice is both intersectional and intergenerational. And you refer to that so strongly in your own remarks, in terms of it really being an ecosystem of change, it really being an idea of justice that's beyond just the procedural aspects, but really the lived experience of law. So the question I want to put to you first, on behalf of the World Justice Forum community, really is how we strengthen that ecosystem, and where then are the opportunities for the legal community at large to really work much more closely with the community of change makers, the community of activists on the ground, to make that idea of justice in its broadest sense, whether it's environmental, political, social, or economic, really come to life for people who are at the worst end, really at the receiving end of those struggles.
Thank you, Lisa. I think what I struggle with in my own profession is that you have a profession of people who have studied very hard, who have often reached the top of their profession. And it's hard work to be a lawyer. I say all the time, it takes a lot out of you if you're doing it right. You are probably working incredibly hard. And what often happens is a sense of kind of insularity within the profession. And unless you are affirmatively seeking out the opportunity to hear other voices, you can be quite successful in this profession, walled off from anything that really challenges your view or your understanding of what the law is or how it is experienced. One of the great things about being a civil rights lawyer, for me, has always been that connection to the clients, is learning what you don't know. And that is the space in which those kinds of adjustments and shifts can happen, because there is an exchange and a dynamic between and among those in the profession and those outside of the profession. One thing that I think is critically important is to actually create the ecosystem within the confines of the practice. So leading LDF the last 10 years, I was determined to bring certain things into the building, right? That in addition to being an organization of lawyers, I wanted us to build out a department of organizers, which we have permanently on our staff. I think it's 5 or 6 at this point, so that we can be sure that we are connecting with the communities that we serve, that we should not presume that just because that I am a Black woman and emanate and come from those communities, that I know what those conversations are at the moment. So we have a staff of organizers. I also created something called the Thurgood Marshall Institute, which was an idea that had been germinating at LDF for a number of decades, and I was determined to bring it to fruition so that we could bring in the voice of scholars and writers who are engaging and doing research and doing field research. And we could kind of have a feedback loop among litigators, among our policy team, among our organizers, among those engaged in research. And so I think what it requires is a kind of commitment to learning in the profession, and not just kind of reaching a point in the profession and then cutting it off.
I love what you said about learning what we don't know. And I mean, one of the things that has come up really significantly during the pandemic is the area of really significant ignorance, but also significant lack of ability for regulation is really the use of technology to intimidate, to harass activists, to block access to justice, the use of artificial intelligence for surveillance, for censorship. And this really seems to be a discussion across countries about where there really is need for stronger regulation, for stronger law, but the inability really to find those really concrete examples of what needs to be done and how lawmakers and communities can act together to really protect and prioritize the safety of citizens. So what do you think we can do better to hold big tech accountable and to really go after many of the political and economic elite who are enabling this kind of surveillance and intimidation of activists?
Now, this is a really huge issue. I spent a lot of time over 2 years, 2018 to 2020, engaged in conversation with particularly Facebook around many of these issues, and around hate speech on the platform, which was really creating quite dangerous situations around the world, and certainly in the US with attacks on Muslim populations that were being perpetuated on the site, and voter disinformation that was being used to try and suppress votes. It is also true that the platform was used by outside forces that were later traced to Russia to actually kind of take on the role through kind of bots of people pretending to be Black activists to stir dissent within the activist community and to essentially create more dissension and chaos around race in the US in the run-up to the 2016 election. So we had many of these conversations, and I came to the position that the answer is regulation. It begins with a different mindset, I think, about who these big tech companies are, what interests they represent, what obligations should be placed on them. So I was just talking with Judge McCune about this. I had many conversations with Mark Zuckerberg about, in the US, our First Amendment, which offers very broad protections for speech. But the First Amendment really applies to governments not interfering with speech. It's really not about the platform. I mean, the platform can restrict whatever it chooses to restrict. The truth is that the business model of it, which relies on engagement and clicks, necessarily actually invites the kind of more lurid speech that attracts people to the dynamic. So the first thing is understanding the business model itself, and understanding whether that business model is in fact consistent with democracy, and being willing to challenge elements of that model and demand that protections be put in place. The second thing is a little bit more esoteric, and it's really about not conceding a kind of superior knowledge of tech leaders, because they do have superior knowledge about things like algorithms. They do not have superior knowledge about racism, gender bias, discrimination, law, or democracy. And so I would have these conversations in which I would, say, listen, I couldn't challenge you on the algorithm. I don't know anything about it. But you're challenging me on voting misinformation when you actually know nothing about it. And this is what I do for 30 years. And so I think the original vision was that these people who were creating these technological platforms, which we all use and enjoy, had such innovation about them that we didn't want to interfere with that innovation by imposing the restrictions of regulation on them, and that it would interfere with the product itself. And they would say that. They actually say it would interfere with their ability to innovate and so forth. And I think we just have to let that go. I talk often about when I was a girl in the US, a young girl, we didn't used to have laws that required you to wear seatbelts in your car. And those laws came about as a result of recognizing the harm of auto accidents and how many lives could be saved if we used seatbelts. And I can remember, I come from a large family, I have 9 siblings, and I can remember that my father was outraged by the seatbelt law, because the seatbelt law now meant that you had to sit in a seat, and we kind of just, however many you could fit in, you fit in. And so he, in the beginning, he was outraged, he didn't want to follow the law, and then, you would get pulled over, you'd get a ticket, and eventually, obviously, he and everyone. Now you get into a car, certainly in the US, and you instinctively reach for the seatbelt. You can't imagine not doing it because it's become such a part of the culture. And this was just in the early 1970s that seatbelt laws were put in place. What the car companies used to say when they resisted it, because they resisted the seatbelt, and what they used to say is it will interfere with the design, the innovation, the experience. I mean, there's always that argument. Yeah. And so I think we have to get past that with the tech industry as well, and understand that they should be willing to be subjected to the same regulation that anyone else who makes a product would be subject to. You cannot sell a toy in the US to children without it going through the Consumer Product Safety Commission to make sure that it will not harm a child. And yet a tech platform can decide they're going to make Instagram Kids without having to have that regulated by any government authority to determine whether or how it may harm young people.
Yeah. And that's so true. I think we constantly get fed short-term economic, political reasons as an excuse to move away from the long-term, commitment to justice, to values, and I think that's, again, why we're here, right? Because we want to honor that legacy of moral conviction, of being able to challenge, when fundamental values are at risk, to be able to rise up to that challenge. Before I get to my next question, I want to remind all of you who are here in person and those online to please send more questions and comments that we can take up. But in continuation of our discussion here, many of these challenges are global, and in fact, the top 3 global violations in relation to civic space are the attacks on protesters, so the attacks on freedom of peaceful assembly, the intimidation of individual activists or human rights defenders, and then the introduction of emergency laws, quote unquote, so laws that are brought through very quickly, especially in the pretext of the pandemic, without sunset clauses, and which have a disproportionate impact on our ability to enjoy our civic and democratic freedoms. So in this context, what are the opportunities for transnational accountability? And of course, we're sitting in The Hague itself, so what kind of institutions and mechanisms should all of us really be working towards to ensure that we're able to then, at a global level, defend the rights of people on the ground?
Yeah, I think this is, I don't have the magic answer, but I think you're raising a critical issue, which is, it almost relates back to your first question. The only way you can learn what you don't know is to be in a profoundly uncomfortable space. And protest is an uncomfortable space, you know? In the US, when young people started posting videos of police violence against unarmed black people, when people could see police violence against protesters, it was incredibly uncomfortable. But it actually ensured that we could document this truth that you're describing. And in fact, one of the most seminal moments, I think, in the US and around the world were the protests that happened in 2020 after the video of the torture and murder of George Floyd in Minneapolis. We had protests in all 50 states in the US. And those protests were met in many places by police violence that I think people had never seen. Or they had seen it only visited on black protesters. They hadn't seen it visited on white protesters as it was during that period. And so I think we do need to be having a conversation about what it means to infuse a healthy democratic legal system with voices of challenge, with the uncomfortable space, which is the only way you learn. And I'll tell you, it's interesting, even within the context of those who are fighting for justice, we too have to learn and are often placed in an uncomfortable space. And that's where our innovation comes from. And so to the extent we think that maybe we're do-gooders and therefore we're outside of this obligation to face this, to be in this space of challenge, it is in fact not true. And so protest is actually essential to our work because we also can drift and take our eye off the ball as we become kind of embedded in our own comfortable ways of problem solving. We see this all the time, particularly intergenerationally, where you find that the older activists or civil rights lawyers are made uncomfortable by the demands of the younger generations engaged in protest. This was true in the US during the civil rights movement. Thurgood Marshall, who we revere, was very uncomfortable with the activism of Martin Luther King, who was 26 when he was leading the Montgomery bus boycott. And Marshall thought, well, the way we do this is we use the law, and these activists on the ground were boycotting and were being arrested and so on and so forth. And you saw that tension. But Marshall had to learn. He had to learn that young people were demanding something else. They were demanding something more. And I think that's really important to keep that valve open so that we are not actually victims of our own limitations. And so we ought to be talking about, first of all, the fact that there is a global movement to shut down protest, once again, including in the US. We've been involved in litigation in the state of Florida, where the governor signed a law to try and stop the protests that we saw in 2020. And part of the law legally immunizes drivers, people in cars who drive into protesters. This is the kind of thing that we're seeing. So number one, we have to begin to document this as a transnational problem, but also make a transnational commitment to understanding that you cannot be talking about strengthening the rule of law if you don't have the valve open for the voices of those who actually challenge whatever is the status quo. And to understand that we too may be captured, and therefore that valve has to stay open.
Absolutely true. And I'm going to jump into the questions now, but maybe just to build on one of your points to say that the protests are always and often about the immediate change, right? It's the urgency for regime change, for legal change, for a change in way that things are done. Whereas the legal community, I think, really represents the idea of long-term transformation because you have the grit and the persistence to get through and see how it could influence a generation of how life is lived, essentially. So what do we need to do better? And this is the challenge you can throw to me and colleagues like myself who work in civil society. What do we need to do better in order to bridge that, the urgent, immediate action with the long-term vision of justice?
Yeah, this is actually interesting that you say this because increasingly what I'm seeing, Lisa, is I'm seeing the activist community actually be quite bold about a long-term vision of what they want the world to be. in a way, you know? And so I'm not quite seeing that dichotomy that I think existed in the past. I'm actually quite heartened. I think that's part of the challenge, that I'm seeing young activists, whether they're talking about climate, you know, whether they're talking about gender equality, whether they're talking about violence, whether they're talking about economic opportunity, environmental justice, being much more ambitious, frankly, in a long-term vision of transformation than those of us in the legal space who also have a vision of transformation that is long-term, but begins from the platform of existing law. And that in and of itself has its own kind of restrictions. So I actually think we're in a moment, and this is always the difficult calibration, that when things are unraveling, it is dangerous, right? And you know, deeply dangerous. It is also true that when things are unraveling, somewhere in that danger is an opportunity to think in even more dramatic and creative ways about what you could create. And I'm always kind of caught between trying to impress upon people the danger of the unraveling, but also leave space and make sure that we're taking advantage of the opportunities created. When people begin to see things that they have challenged break down, I mean, I find this challenge all the time when I'm litigating, you know, am I trying to go back to 10 years ago? Was there no discrimination then? Am I, you know, for all the people in the US who rail about Trump, and I said, well, long before, you know, I've been a civil rights lawyer since 1988. So we have to be careful also that, that we create those opportunities for thinking more dramatically and more in a more transformative way. And I actually think that people who are more engaged in the activist community actually at this moment, maybe perhaps because so much is unraveling. And I wouldn't underestimate also the thinking about climate disaster and imminent climate disaster and the way that's affecting how how young people feel the urgency of a transformative vision, right? That also is affecting, I think, a sense of the stakes being even higher and the need for transformation being even more dramatic.
And it comes back to that point of the understanding of intersectional justice, right, and how everything connects together. So there's several questions here. I'm going to read the one that I love the most. So it's Sherrilyn, what inspires you and what gives you hope?
Well, first I would say, I think I would be remiss if I didn't say the arc of my own family's life inspires me. I don't think that, you know, my grandmother, who was a domestic, was imagining I would be on the stage of the World Justice Forum at any point. You know, as I told you, I came from a very large family, and we didn't have money, and we didn't. Whatever I and my siblings have been able to accomplish in their lives was the product not only of, you know, the determination of my parents and hard work and sacrifice, but also the work of civil rights lawyers and activists who opened up space for us to be full citizens in a country where we would not have been full citizens. So I feel like, you know, I cannot pretend that I don't know that change can happen, because I do know. Yeah. So that's the inspiration. What is the hope? The hope is exactly what I was just talking about, which is, number one, every year I am encouraged, I'm discouraged by a lot of what I see, but I'm encouraged by how many people around the world are committed to justice, equality, and the dignity of human beings. There are more of us than there are of those on the other side. Now, we may not be quite organized the way we should be, and we may not get it all right, and we may not have all the power, but there are more of us. And so I'm encouraged by that, encouraged by the boldness of young people. And lastly, I would say, someone I admire very much, a civil rights lawyer named Hank Sanders, who lives in Alabama in the US. And he talks about his work and the period in the civil rights movement. And he always says that we should never believe that we don't have the power to make change, that he can remember in the civil rights movement when the white supremacists had all the power, he said. They had all the guns. They had all the dogs. They had all the laws. And we had our feet marching. We had our songs. We had our faith. We had the truth. We had allies. And we were able to overcome that. And so I'm a big student of history, of legal history in particular, and of the ability of people to overcome. And these are the cards we were dealt, and we have an obligation on the shoulders of those people to do our part in our time.
That was so powerful. I'm getting goosebumps just listening to you. Thank you so much for that. We have time for one more question, and there's another very interesting one here. So the US is often projected as a model society and the example of what rule of law should look like. So what do you think the US could learn from other countries in terms of doing better at access to justice and in fact just,
Oh, a lot. You know, I remember after the South African Constitution was finally enacted in the 1990s, we were all so jealous, you know, those of us who were civil rights lawyers in the US, because of the kind of specificity about rights that the Constitution contained. I talked about Justice Ginsburg. She was very moved by her time living in Sweden, and very much borrowed from her experience and understanding of how women could have more access to what they needed to be able to work and raise families and so forth. So we're constantly learning from other countries, and we talk about this all the time. You know, the U.S. is actually an outlier in many areas, obviously around things like guns and violence, you know, around access to health care. There are many areas in which we can learn, and there's so much innovation happening in the profession in other countries that we also could learn from. We're creaking a bit, we're a little bit creaky at this point, and we've lost a step in thinking through how to scale innovation. And we're such a divided country at this point that it's very hard to make big changes happen. So we're in a constant process of learning, and one of the things we have to learn is how to create elements in our political process that allow us to make the kind of transformation and change that we need to be able to make. So this is an interesting time in the US. I think it's actually healthy for people to see the challenges, the rule of law challenges that we're having. No country's legal system will always remain perfect. It has to constantly be dynamic and changing, and we're discovering that ourselves. But we have a very strong legal system, and we have a very strong set of leaders who are determined to strengthen it, which is, I think, admirable and important. And we have a huge ecosystem that is not afraid to approach transformation of our legal system. So that's a positive thing. But we regularly bring in examples from other countries to try and break through what some of the log jams are in our country. Certainly for, you know, the kind of work that I do, our death penalty cases alone compel us to look to other countries to try to help courts understand, you know, what is happening in our own country. So yes, we are very conscious of it. There is also a movement to ensure that we do not actually integrate the experiences of other countries in our jurisprudence, but there are many of us who are pushing back against that.
And that's the significance of forums like this, right?
Yes.
Where you have a direct experience of learning from each other. And of course, the innovation awards at the end of the day are going to be the highlight in that aspect.
Yeah.
So we just have time, you know, for a few more remarks. But really, is there anything you'd like to say to all of us in terms of inspiration we can carry back home, or challenges maybe of what we can do better?
Well, I'm inspired by you, and thrilled to see, you know, so many of you here and engaged, both present and online. I think we're facing a very critical moment, not only in my country but in the world. And when I was saying earlier, you know, kind of these are the cards that we were dealt. I feel very strongly about us taking up our obligation to protect democracy, to protect democratic values, to protect the rule of law, to infuse it with what we learn and what we know about the way the law operates in the lives of those who see its weaknesses. And it is an obligation as important as, an obligation to go to war, against fascism, or it's our job. And those of us who are able and capable of being in this room, or able and capable of having registered for this conference and being online, are the beneficiaries of struggles that came before us. And whatever we are doing today, we should be asking ourselves, what do we want those who come after us to say about us? Justice Ginsburg once said that, again, she was not a woman who had a very refined, a very developed sense of humor, but she said, what's the difference between a bookkeeper in the garment industry and a Supreme Court justice? And the answer was 1 generation, because the bookkeeper in the garment industry was her mother, and she was the Supreme Court justice. And she was very conscious of the doors that had been opened that made her life possible in ways that provided opportunities that would not have been available to her mother, who she thought was brilliant and who she lost when she was a teenager. So we should be mindful of that as well.
That is so powerful, and I'm going to invite us to all stand up and give you a standing ovation for those remarks. Thank you so much. Good. I'll take you down. Thank you.